substance abuse counseling and treatment if directed. No assaultive or threatening behavior. Alcohol tests and drug screens. You're not to use any alcohol or any controlled substance. That includes marijuana. No alcohol. That's our most common home wrecker is alcohol.
I don't drink, Your Honor, so I don't have to worry about that.
Right.
My biggest concern though with that, I'm gonna be honest, is I've been smoking weed since I was 8 years old and I have a shattered neck. So how do I go about trying to do that?
If you get a medical card.
Okay, will they recognize that?
Yes.
Okay, I will try to get my stuff
Since
in order
you're
to start.
8 years old,
Since I was 8 years old, Your Honor.
I'm gonna tell you something. You screwed up your brain. Nobody smokes marijuana at 8 years old, and they've done some significant testing about the effects of marijuana on an adolescent and developing brain. And
I believe this is actually gonna help me, to be honest with
I
you,
hope
Your
so. I
Honor.
want you to be clear-headed. I don't want to get on a rant, but middle school kids, high school kids smoking lots of marijuana, it affects their brain development.
I feel like that's true.
And Lord knows, I went to school with lots of people like that and have lots of friends that smoked a lot of weed when they were young. But 8 years old it's affected your brain development. You're to sign a release with Pivotal. You're to continue with your treatment. Now, marijuana is legal for recreational purposes or any purpose as an adult. When you're on probation, the rules are different. Although we recognize, in fact, the Court of Appeals says if they have a valid medical card, they are entitled to use it. I've had people successfully complete sobriety court with a valid medical marijuana card. I'm not sure we're trading one thing for another, but they certainly are a better place than they were when they started. No drugs, no alcohol, sign a release, continue treatment with Pivotal, no assault or threatening behavior. I'm lifting the no contact provision.
Thank you.
You can go back in your own home and under the category of maybe when you miss it, you'll appreciate it more when you get it back. Sometimes it's hard to tell mental health symptoms from methamphetamine symptoms. And heaven knows if marijuana compromises your brain, methamphetamine really does. When's the last time you used meth?
It's been, I want to say since February.
All right, well, that's a good start. Not to mention,
I'm trying to keep myself on the straight and narrow, Your Honor.
You got better things to spend your money on.
Yes, sir, I do. I got four other ones at home.
Everything you spend on methamphetamine is money not available for your family.
Your Honor, I'd like to ask a question of the court. So is there services, let's say if you've had a death in your family and you haven't learned how to cope with that, is there services or anything that can help with that?
Well, Pivotal certainly should be addressing that. Are you sharing that with your counselor?
Yes, I have. So maybe that's something I'll find out when I go on the 26th to my counselor.
I dealt with another gentleman. He has PTSD from the Iraq War. And he's been struggling with it for years. And then you throw cocaine into the mix, and sometimes it's hard to discern the drug effects from the mental illness. Methamphetamine is certainly, you're actually on probation in 273 SM. And let's do the fines. The fine is $0. There's a $75. Oops, that's the other one. Pay for the class and $600 restitution to rent a center. So 75, 50, 150, 480, 600, and you'll pay for the class. That's $1,355. It did post a $2,000 10% bond, so it's $180 to reduce from that. Court keeps 10% of a 10% bond by statute. That equals 1175, and it's due in 1 year. Anything less than a year would reduce the monthly oversight. So you're on a domestic violence deferral probation, meaning I don't want any assaultive or threatening behavior, and I want you to complete the treatment class.
Yes,
In
sir.
addition, because of the past drug issues, we're going to do some drug testing and get a release from Pivotal. So you've had months of turmoil, loss, disruption of your family. It's time to get back with your family, get back to work, take your meds as prescribed, stay in contact with your counselor, get your head straight for maybe the first time in some time, and get things better.
Yes, sir.
Oops. All right, we got a lot of work to do. Ladies, thank you for being here. The no contact provision is lifted. You guys can go out to lunch. You owe a lot of amends to your mother and your wife, but let's see if we can get better here. Mr. Dahlia, you go take that downstairs to the probation department. When they're done with you, you can go out to lunch with your family. Ms. Campbell, thank you for your input on this.
Yes, you're welcome.
It was a plea agreement where everybody was aware of the circumstances. All right, that completes our morning docket. I have a meeting at lunch. I don't like lunch meetings, and I sure have a lot of them. And we'll be back at 1 with our afternoon docket.
All right, let's talk about that. This hearing with Judge Middleton really had the full range of what you expect when substance use, probation terms, and family life all collide in a courtroom. Judge Middleton came across in his usual fashion, firm, direct, but not without some humanity and humor woven in. He laid out the conditions, clearly no alcohol, number-controlled substances unless there's a valid medical card, no threatening behavior, and he took the time to remind the defendant how early marijuana use can affect brain development. That wasn't a lecture for its own sake. It was Middleton doing what he often does, using the bench as a teachable moment. You could tell he wanted this individual to step back and really think about the long-term picture, rather than just the next test or condition. The defendant, Mr. Dahlia, was candid, maybe more candid than most about his history, admitting to marijuana use since the age of 8 is no small revelation, and while he claimed it helps him cope with pain, you could see that this disclosure gave the judge reason to pause and explain the scientific side of things. To his credit, Dahlia didn't come across as combative. He seemed genuinely concerned about how to move forward, asking the court questions about medical cards, coping services, and counseling. That willingness to ask instead of dodge felt like someone trying, albeit imperfectly, to find a path out of chaos. His demeanor was less defiant and more searching, which probably played a role in the judge's decision to lift the no-contact provision and let him return home. The court also had to juggle practical matters, fines, restitution, and probation oversight. Middleton balanced those details with a clear message. You've had months of turmoil. Now it's time to get back to family, back to work, and back to stability. He even lightened the mood a bit at the end, telling the defendant he owed amends to both his mother and his wife, before joking about his own dislike of lunch meetings. That's classic Middleton keep-in. The authority of the bench intact while showing enough levity to remind everyone this is still a human space. Not just a cold bureaucracy. What stood out most here wasn't fireworks or dramatic confrontation, but rather the ongoing theme of how courts try to balance accountability with rehabilitation. The attorneys and probation staff didn't make a spectacle. They quietly handled their roles, with Ms. Campbell providing input when needed. The atmosphere in the room, despite the heavy topics of addiction, family strife, and financial restitution, was surprisingly calm and even optimistic by the close. Judge Middleton's final words weren't just orders. They were almost a pep talk to get Dahlia to straighten up, lean on his counselor, and maybe, for once, clear his head long enough to start making progress. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.